Hello my Nigerian people, you are welcome to my channel. You see these governors, they are thank God in this country. Even at times they are more powerful than the president. But well, whatever the outcome is, we have to be patient in whatever we are doing, because tomorrow will tell. The man who, as Ogun governor, terminated the Chinese FM's contract that has now put Nigeria in an embarrassing situation, has defended his decision. Ibikunle Amosu, who governed Ogun between 2011 and 2019, explained that his government acted due to a dispute between two Chinese firms over control of the six free trade zone. Mr. Amosu's explanation on Saturday came a day after the Minister of Foreign Affairs, Yusuf Tuga, warned state governments against signing international agreements without due consultation with the federal government. Premium Times reported that a Chinese firm, Zhongsunshan Fucheng Industrial Investment Company Limited, obtained a court order from a French court to seize three of Nigeria's presidential jets after the Ogun state government allegedly breached a business contract in 2016. The firm has agreed to release one of the planes, but is based on the court order, holding on to the other two, as well as some other Nigerian properties in it secured through another British court order based on the same matter. In his first reaction since the scandal broke, Mr. Amosu said his government intervened due to the dispute between Zhongfu International Investment, FXE, and another Chinese firm, China Africa Investment, FXE. In a statement titled Presidential Jet Seizure, Zhongfu firm is an impostor. Mr. Amosu explained that when he assumed office in 2011, the two Chinese companies laid claims to management rights over the Ogun Guangdong Free Trade Zone. He said the rivalry between the companies soon worsened and threatened public peace and safety within the zone and neighboring communities. There were claims and counterclaims as to who between the two was the lawful respective of the original joint venture. Guangdong Province, China, and consequently, who had the right to manage the zone, he said. According to the former governor, Zhongfu International was appointed as interim zone managers based on damaging information it gave about China Africa Investment, FXE. Zhongfu International Investment, FXE, pretended to be a concerned and genuine tenant and zone stakeholder, volunteered very damaging and destructive information about the official representatives of Guangdong Province, the joint venture and lawful zone managers, China Africa Investment, FXE, and subsequently requested to be appointed as interim zone managers based on the information that at the disposal of the government at this time. Zhongfu International Investment was on 15/03/2012 appointed as interim zone manager, pending further evaluation. The whole idea was to ensure that someone was in charge and thereby prevent unwholesome and untoward development in the zone pending the completion of our fact-finding exercise. He stated, Mr. Amosu said his government later discovered that the information and claims by Zhongfu International Investment, FXC, against China African investment were tissues of lies unknown to Ogun government at the time. Zhongfu International Investment merely sought to be market China African investment, FXC, and to surreptitiously covered the state-owned assets of a Guangdong province in China, together with the zone ownership and management rights of their business rival. He added, he said the Chinese government, through its diplomatic note 1601, dated 11 March 2011, clarified to the Ogun State government that China Africa Investment, FXC, was the rightful investor. He added that after due consultation with the state security services and the supervising agents, NEPZA, the Ogun government served Zhongfu International with a formal termination notice dated 27 May 2016. The former governor said the termination of Zhongfu International's contract as the interim zone managers of the Guangdong Free Trade Zone led to a series of litigations and petitions. We successfully defended our actions and at all levels before these organs of government, and they all agreed with our position. Shortly after our administration left office in May 2019, Mr. Amosu stated he urged the federal government not to give in to the demands of Zhongfu International, adding that it is concerning that a purely business dispute between two Chinese nationals and corporations have now degenerated into an unlawful attempt to appropriate Nigeria's sovereign assets. While speaking with reporters at the Lamabo International Airport in Equatorial Guinea, Foreign Affairs Minister Tuga insisted that subnational governments should always be careful when entering international agreements. He assured that his ministry and the Attorney General of the Federation were working to resolve the issue legally and diplomatically. Yes, the Attorney General and I are working on it, both diplomatically and then from the legal perspective as well, to ensure that this issue is resolved, he said. The minister noted that the federal government was unaware of the negotiation process and the agreement the Ogun State government made with the Chinese firm, which has now resulted in a lawsuit. Speaking further, he explained that when subnational actors like state governments embark on the international negotiations without the expertise of relevant ministries, they make the federal government vulnerable to unnecessary litigation. This is part of the problem when subnational actors like state governments take it upon themselves to go into international arrangements without recourse to the Ministry of Foreign Affairs, without recourse to the federal government, and then when it goes awry, we are left with the problem to deal with. That is why it is always important that such arrangements be registered with the mission there. With the embassies, with the Ministry of Foreign Affairs, and with the federal government. This is something that Ogun State, under a different administration, not this governor entered into that we are not aware of. All we know is that they are going after Nigerian assets. That is why foreign or international negotiations are not the purview of subnational actors. You should always have those that are experienced in negotiating this sort of agreement on your term, he stated. The contract. In 2010, the Ogun State government and Songham Funged Industrial Investment Company Limited went into contractual agreement to develop a free trade zone in the state. However, the Ogun State government terminated the agreement in 2016 and appointed another manager for the free trade zone. This prompted the Chinese firm to launch an investment treaty arbitration against Nigeria, citing the bilateral investment treaty between the People's Republic of China and Nigeria. In 2021, an independent arbitral tribunal awarded Zongham $55 million, 675, in addition to an interest of $9.4 million and a cost of £2.864 million payable by Nigeria to Zongham. It is this sum that the Chinese firm once paid and that has led to the French and British court order. You see what we are saying, my people? You see, they will do the contract, arrange with Chinese people or other countries. They will not inform the federal government. Now, federal government now is suffering, bearing the cost of everything now, the problem, the shame and embarrassment. It's a pity. My people. See, what do you see to this? Give your opinion in the comment section and subscribe to this channel. Like, love, and share. Thank you and God bless. Amen.